Minister. You know it better.
Madam, we've all had the privilege of listening to the views of a large number of members. You're right, you made a point in response to what the Honourable Member just said. With regard to customs, the Honourable Member in fact made two very valid points. The first was that always the community must be consulted when you amend personal laws. Secondly, even within the parameters of personal laws, there have always to be a distinction maintained between the rituals and the customs which are personal to the religiosity of the community. The second aspect is in relation to various rights which emanate from either marriages or divorces. I do not think there is any need by law at this stage or at any stage to say that everybody will follow the same custom, because customs in different communities will always be different, and therefore that's an area which the communities, as they evolve, they are capable of taking care of themselves. We have really to be concerned more as far as the arena of rights is concerned. Madam, there have been several very important suggestions which have been made. At the very outset, let me suggest this, that even before the initial amendment was introduced in the Honourable House, a conference of the leading members of the community had been organized by the Department of Legislation. Their views had been taken. And not only the views had been taken, it was also a constitutional duty of Parliament to legislate in relation to two areas, particularly because those areas had been struck down by courts. We could not afford to leave a vacuum as far as law was concerned. We have to remove the non-discriminatory law. We have to bring in a non-discriminatory law and remove the discriminatory law which the courts had struck down. After we introduced, some more consultations were held. Initially there was many views which were there. The Christian women very strongly argued in favor of a particular viewpoint, and I must be also very grateful both to the Christian women organizations and also to the church authorities, who subsequently all converged to a single point of opinion and supported these amendments before the Standing Committee. The Standing Committee also has returned a finding which is unanimous, and except one area, the Standing Committee accepted all the suggestions and we have dittoed it. And that one area is again the last one which the Honourable Member mentioned. What about courts created by religious organizations? I'm afraid this is something we cannot agree to. I'll just quote from what the Law Commission had said in this area. The Law Commission's 15th report, which was the first report on the Indian Divorce Act, had said, it is the courts constituted under the law of this country that have the exclusive authority to determine disputes relating to civil rights, and there can be no surrender or abdication of that authority. You cannot have parallel proceedings going on before courts which are informally constituted by people. The only institution of courts which law recognizes is courts created under our constitution and under our law. And therefore this suggestion that there must be a parallel jurisdiction did not find favour either with the Standing Committee or with the government, and that's the only suggestion of the community, or a section of the community I may say, which we did not accept. I must say that this is not the only changes. Whenever we speak of legislation, we speak in terms of having comprehensive laws, but there are several aspects of laws which require a reform. And merely because some reforms have not started in some areas is no reason why we must hold up reforms in other areas where a situation has come where reforms are now easily possible. In fact, a study of this law itself will give us an illustration of how consensus within the community itself determines itself. We've had in the last 50 years several efforts made to reform this law. As I mentioned, this 1869 law is based on the English Act of 1857. England repealed that act in 1923. And in the second part of the 20th century, we had repeated resistance to the amendment of this act in India. But then ultimately the community all got together and said we must change and improve upon this act. A very important point was made by Mr. Saifullah. He said, what is the advantage that women have unless you amend some corresponding provisions of the criminal law? And the chair commented that we were unable to comprehend what the relationship between the two was. This is a civil law, a personal law. In this personal law, there were discriminatory grounds given to a man and a woman. There were several other discriminatory provisions. There was also an obsolete provision of going to the High Court. All those aberrations have been corrected. This has nothing to do with the criminal law liability which a husband may incur in the event of his committing bigamy or polygamy. The criminal law provision which Mr. Saifullah was referring to was, under our criminal law, if somebody commits bigamy or polygamy, the right to institute the criminal proceeding vests only with the aggrieved wife. Now, whether there is a need to change this or no need to change this is an issue which is entirely separate, which can be independently discussed in this Honorable House. But that is no ground till we amend that law and give to strangers also the power to initiate prosecutions in the event of bigamy or polygamy. That is no ground till that is done. We stop the process of reforming a law where reforms in fact have been long overdue. There was one suggestion which was made by Mrs. Dubey, when she particularly said that why are you when you are removing the 1/5 ceiling, why are you keeping it to 1/3? Why don't you leave it to the courts to determine what the quantum of maintenance should be? I may only correct that this is precisely what we have done. The original law said 1/5. We have removed that 1/5, the maximum that the wife could get. She could get less than 1/5. We have removed that condition, and today it is entirely within the realm of judicial discretion as to what is the quantum. We have not kept any limitation of 1/5 or 1/3 as far as these amendments are concerned. There are one or two minor changes which exist from other personal laws. For instance, on the dissolution of marriage by consent, as was Premdasan mentioned in the end, that the Catholic law says that those whom God has united, law cannot separate. Well, that's the essence behind the respect of marriages which the Christians have for their marriage, the reverence that they have for their marriage. Now, it was therefore the community which suggested to us that do not use the word divorce at any stage in the text of the Act, and therefore we decided to use the word dissolution, keeping that sentiment in mind. But there were certain other changes that they wanted. For instance, in the Special Marriage Act and in the Hindu Marriage Act, the period of separation for the purposes of consent divorce is 1 year. But here the entire community expressed a view that we want a slightly larger period. So for the couple to really determine on account of their entire tradition and relationship of religion and separation of this kind. And therefore, with the consent of the community, we fixed the period of 2 years. Since this was a point on which there were some strong views the community had, we decided to accept and honor those views. There can be conflicting views we have in this house, but this was, as I said, since it's a personal law reform, we did respect the views of the community itself. There are other one or two minor changes which we have where there is a distinction between the Special Marriage Act and this law. Mr. Gowda asked a question, raised two very valid questions. One was in relation to having a neutral personal law which defies religion, where people of any religion can choose to get married under that law. But yes, we do have the Special Marriage Act specifically for that period. It's a law, you can belong to any religious denomination, you can get married under that act, you can get divorced under that act, you will incur liabilities under that act. Even today, if Christians chose to marry under the Special Marriage Act, they were welcome to do so. Any person belonging to any religious, in fact, trans-religious marriages are also held under that act. It's a law which goes beyond this.
What the emphasis was, they may be married in different laws, under different laws. My submission is, or my saying, under whatever laws they have married, if they want a divorce, under those circumstances, a law is to be made, that law has to be given powers to overriding all the personal laws, and a relief is to be given under that law.
Well, I wish we could, in the terms of national consensus, parliamentary consensus, reach a situation of that kind. But we have not done so. And therefore, I think till the time we do so, it would be always advisable that whatever provisions of personal laws are which otherwise are discriminatory or go against human dignity, if we with the concurrence and the consent and participation of the communities try to correct those aberrations, that's a process which we currently are involved in. There are also questions which you raised, which I completely agree with, that we are trying to cut short procedures, we are trying to fix time limits, but will that ever happen in courts? Well, let me straight away start with a confession that as far as the government is concerned, the government can actually try at the state level or the central level create infrastructures. The parliament will amend laws, give a mandate and the spirit behind the law. Well, this is how we want the law to be operated. These are the time limits we have. But ultimately, this is one area where the management and administration of those laws, particularly relating to the administration of justice, is entirely within the realm of judges and lawyers. And therefore, this sense of expediency, which we are trying to indicate through these legislations, must also be simultaneously reflected in the implementation and administration of these laws by our judges and lawyers. Otherwise, you are right, we may keep amending the laws, we may keep fixing, indicating the periods under which the public policy requires expedition, and we may still be faced with a situation, as the example of the Bangalore case you gave, that even the orders itself are not being implemented, that we may not be able to make a substantial headway. Dr. Ramanna made some very interesting points, and I think some of these points would require the legislature at a suitable date to actually consider the consequences of this. You mentioned that number of divorces are going up. In India they are not so high, but in the Western societies they have increased. But one factor which most civilized countries have kept in mind, that even when divorces have increased, they have all been trying to make divorce a very costly proposition. When you divorce your wife, it is not very easy to walk out of marriage without paying for it. And therefore, not only you pay for it, you pay effectively, you pay urgently, so that this also has a social constraint people keep in mind. You mentioned that perhaps people may start a situation where they may bypass the law, so as to bypass the law, bypass the lawyers, bypass the courts. Well, such situations have arisen, and some countries, when we are not confronted with this situation in a big way. But if at all, unfortunately, one day we were, law would have to take notice.
We are not confronted with it in the middle classes, but in the lower classes, they just don't care for you.
Well, I am sure, just as you have a chapter on alimony, you may have to provide some suitable compensations as far as children are concerned, the other spouses to the marriage are concerned in a situation of this kind. Already there are world jurisdictions which have started speaking in terms, which have started recognizing palimony. And therefore, the illustrations which you had in mind are not very difficult to envisage. We may try and avoid the law, but I think law also has the ability in these kind of situations to catch up with. But you are right, when technological developments take place, then who the spouses are, what the liabilities are. In the case of artificial insemination, who the father would be. In the case of human cloning, what the parental rights would be. At some stage, law will have to catch up with technology when those issues do arise. There is a link between the two. I am afraid today we have no such situation. We recognize that, but I am glad that you have, in fact, cautioned us about what could be a possible scenario in the decades to come. So I am extremely grateful to the honourable members who have almost unanimously supported this particular legislation. I think this is one law where reform was long overdue, and I am glad finally it has come. I propose to this honourable House to kindly adopt this law.
What about the law of adoption?
Well, as far as, you see, there are several other aspects are concerned. I must tell you, when the conference was called, there were several aspects of the Christian laws which were taken into consideration. In fact, one of the suggestions was, and a draft law also was prepared by us, which would take marriage and divorce laws and then total them so that the entire personal law of Christians becomes one. There was no consensus on it.
Because it is marriage and divorce together.
There was no consensus on it. And therefore, please permit us to move at the pace with which there is a consensus developing as far as the community is concerned. We have brought those provisions with which there is a very large consensus. In fact, I may only inform, there is yet another provision on which there is a consensus. As many as 23 Christian members of parliament have written to me that they have still a law compared to other communities where they are discriminated against in the law of succession. And we are seriously looking at that. So allow us to do it in stages whereby we can carry the consensus of the community rather than bring in those provisions where there is still an absence of consensus. Therefore, these were reforms which are long overdue. I am sure there would be in years to come. No law can be static. And as and when our consultations with the community and their aspirations also rise, I am sure other reforms would also take place.